In today's video, we will talk about disclosing criminal evidence. Hello, and welcome to Ask Professor Price. I've been a lawyer for more than 35 years and a full-time professor for more than 10 years. People studying law or criminal justice or working in the legal or law enforcement fields need to know the requirements for prosecutors and defense lawyers to disclose certain types of evidence to each other voluntarily, and to disclose other types of evidence when requested by the other side in the case. The dramatic moment at the trial of suddenly announcing a surprise witness in the courtroom, or presenting a critical piece of evidence that the other side did not know about, is the stuff of movies, not reality. The court doesn't want to waste its time on days, weeks, or months of trial if there is a witness or piece of evidence that would cause one side to win or lose the case. Discovery is the important process in which the prosecution and the defense exchange information formally or informally before trial. This can be a list of witnesses, a list of exhibits that the party intends to offer as evidence at the trial, and important information, usually a lot of documents or reports that they might not use all of it at the trial, but they used it in preparing for trial. Discovery is a process that happens in both civil and criminal cases. In the stage of discovery, the prosecution and the defense try to find as much evidence as they can to build up their own case and to attack the other side's case. Some types of evidence in criminal cases include lab test results. For example, if the case involves charges of DWI, lab test results might be the breathalyzer test results, or might be the blood or urine alcohol testing results. Other evidence that can be used in criminal cases include such things as witness statements, police reports, and confessions of defendants. Now, don't get me wrong, the discovery phase does not mean that you basically invite the other side over to your office and open your case file. Neither side is required to open their entire evidence file to the other side. There is protected information in a case file. The requirements of disclosure vary by state. Generally, though, the prosecutor must disclose evidence that tends to prove the defendant's innocence or the guilt of another party who is not the defendant. So, in other words, if the prosecution knows that this defendant did not commit the crime, or knows that someone else did commit the crime, they shouldn't be going forward trying to get an innocent party convicted of something that they didn't do. So if the prosecutor withholds evidence and that action sounds fundamentally unfair, it likely violates the disclosure rules. Please hit subscribe and the thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results, and the higher these videos are in the results, the more people I can help. Thank you. There are benefits to defense attorneys and prosecutors of the discovery rules. When both sides exchange essential evidence, they don't have to waste time and money each going after the same information. For example, if the prosecutor already has the official lab reports and exchanges copies of those with the defense lawyer, then the defense lawyer doesn't have to go to the expense of having to obtain a copy of the report from the lab. This kind of cooperation can save defendants and taxpayers a lot of money. Also, when the parties freely exchange discoverable evidence, this process encourages guilty pleas when appropriate, when both sides know most of the facts. It is true that both prosecution and defense should already know everything that's going to be introduced at trial before the trial ever starts. If they don't, either they're not adequately prepared or the other side did not disclose everything they were supposed to. There really should not be surprises at court that could be predicted. Now, you never know if a witness is going to change their testimony once they get on the stand. You never know what a jury is going to decide. But so far as the factual matters go, there should not be surprises about those. The purpose of reciprocal disclosure, in other words, both sides cooperating on disclosing essential evidence, is that trials should be fair and it should be a level playing field. Factual information about an alibi defense or plans to use the insanity defense, for example, should be known by both sides before trial. The constitutional guarantee against self-incrimination in the Fifth Amendment protects defendants from having to hand over to the prosecution evidence of their guilt. So they are not required to disclose self-incriminating evidence. The prosecution has the burden of proof to establish every element of every charged offense beyond a reasonable doubt. But the defense does not have to do the prosecutor's job for them. Please feel free to post in the comments your questions about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students, as well as people working as paralegals or in the criminal justice field, are the main audience for these videos, but everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing won't cost you anything, but it can help me to reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video about the exclusionary rule and criminal evidence.